Right now, if you passed away unexpectedly, there's a good chance your family wouldn't be able to walk into your bank and immediately access the money in your account. Many people assume a will is enough. In reality, it often isn't. I'm David Maines, and I work with taxpayers and financial matters involving the IRS and banking institutions. I've seen families face unnecessary delays simply because one important document was never completed. If you find information like this helpful, consider subscribing. Every week I explain financial and legal topics in plain English so you can make informed decisions and avoid expensive mistakes. One of the biggest problems I see isn't a bad investment or a tax error. It's a family standing at a bank counter after losing a loved one, only to discover they can't access funds that were intended for them because no beneficiary designation was on file. In many cases, filling out a Payable-on-Death pod beneficiary form takes about 10 minutes, costs nothing, and is available through your bank. Yet many account holders never complete it because they don't realize how important it can be. Here's why this matters. Your relationship with your bank is governed by a contract. In many states, if your account has a valid beneficiary designation, the funds can often pass directly to that named beneficiary without becoming part of the probate estate. If no beneficiary is listed, the account may instead become part of your estate, which could require probate before the money can be distributed. Probate is the court process used to settle an estate. Depending on your state and the circumstances, it can take months, involve filing fees, attorney costs, and waiting periods while creditors have an opportunity to make claims. That delay can create real financial pressure for surviving family members, especially when funeral expenses and household bills still need to be paid. Let me give you an example. Dorothy was a retired school teacher who sold her home and deposited the proceeds into a savings account. She also hired an attorney to prepare a professionally drafted will, naming her 2 children as equal heirs. She believed everything was in order. After Dorothy passed away, her children brought the death certificate and the will to the bank, expecting to access the funds. Instead, they learned that no payable-on-death beneficiary had ever been added to the account. Because the account was solely in Dorothy's name, the bank couldn't simply release the money. The funds became part of her estate and had to go through probate under state law. While the legal process moved forward, Dorothy's children covered funeral expenses and other immediate costs out of their own pockets. The probate process involved court filings, legal fees, and several months of waiting before the estate could finally be settled. Situations like this happen more often than most people realize. That's why I encourage everyone to log into their online banking or review their latest account information. See whether your checking and savings accounts have a beneficiary listed. If you're unsure, call your bank and ask. This simple step could make a significant difference for your family someday. One of the most common mistakes is opening an account years ago and never updating the paperwork. Many people assume their will automatically controls everything they own, but financial accounts often follow the beneficiary designation on file with the bank instead. Understanding how your accounts are titled and whether a beneficiary has been added is one of the easiest estate planning tasks you can complete. Most people assume that if they pass away, their family can simply take a copy of the will to the bank and access the money in their account. In many cases, that's not how it works. I'm David Maines, and I work with taxpayers and financial matters involving the IRS and financial institutions. Over the years, I've seen families face unnecessary delays because one simple piece of paperwork was never completed. If you enjoy practical financial and estate planning tips, consider subscribing. Every week I break down complex legal and financial topics into clear, easy-to-understand information. One of the most common estate planning mistakes isn't a bad investment or a tax problem. It's assuming that a will automatically controls every asset you own. For many bank accounts, what's on file with the financial institution matters just as much, sometimes even more than what's written in your will. Depending on your state and how your account is titled, a payable-on-death (POD) beneficiary designation may allow the funds to pass directly to your chosen beneficiary without going through probate. If no beneficiary has been designated, the account may become part of your estate, and your loved ones could have to wait for the probate process before accessing those funds. That process can take several months and may involve court costs, attorney fees, and other administrative expenses, depending on state law. Here's a real-world example. Dorothy, a retired school teacher, sold her home and deposited the proceeds into a savings account. She also hired an attorney to prepare a professionally drafted will, naming her 2 children as equal heirs. She believed everything was taken care of. After Dorothy passed away, her children went to the bank with the death certificate and a copy of the will. They were surprised to learn that no POD beneficiary had ever been added to the account. Because the account was held solely in Dorothy's name, the bank couldn't immediately release the funds. Instead, the money became part of her estate and had to be handled through probate under applicable state law. While waiting for the estate to be settled, Dorothy's children paid funeral expenses and other bills out of their own pockets. Months later, after the legal process was completed, they were finally able to access the funds. The lesson isn't that wills don't matter. They absolutely do. It's that beneficiary designations are an important part of a complete estate plan and should be reviewed regularly. Before you finish watching this video, log into your online banking or contact your bank and ask whether your checking and savings accounts have a current beneficiary on file. It only takes a few minutes to check, and it could save your family significant time and stress in the future. Now, before you assume this only affects wealthy families, think again. In reality, this issue impacts people from every income level. Whether you have $10,000 in a savings account or $500,000 spread across multiple accounts, the same question eventually comes up. Who has the legal authority to receive the money after you're gone? Many people believe the answer is simple. My family knows what I want. I already wrote a will. My spouse will take care of everything. Unfortunately, estate administration doesn't always work according to assumptions. It works according to the legal documents that are actually in place and the laws of your state. That's why one of the smartest things you can do is spend a few minutes reviewing how each of your financial accounts is titled. You might discover everything is already set up correctly. Or you might find that an account you opened 20 years ago has never been updated. I've seen this happen countless times. Someone opens a checking account in their 30s. Years later, they get married, they have children, they buy a home, they retire, they update their will, but they never update the paperwork sitting in the bank's records. The account continues exactly as it was opened decades earlier. No beneficiary, or worse, an outdated one. That's why financial professionals often recommend reviewing beneficiary designations whenever a major life event occurs: marriage, divorce, the birth of a child, the death of a spouse, a move to another state. Even something as simple as switching banks is a good reminder to review every account. Here's another situation that surprises people. Let's say you have 3 different accounts at the same bank: a checking account, a savings account, and a certificate of deposit. Many people assume that if they complete one beneficiary form, all 3 accounts are automatically covered. That isn't always the case. Depending on how the institution structures its paperwork, each account may require its own beneficiary designation. That's why it's important to ask the bank directly. Don't guess. Ask the representative to confirm every account that has a beneficiary on file, and every account that doesn't. It only takes a few minutes, and you'll have peace of mind knowing everything is documented correctly. Another common misconception involves joint accounts. Some people believe adding an adult child as a joint owner is the easiest way to make sure someone can pay bills if an emergency happens. While that may work in certain situations, it also changes the legal ownership of the account. Before making anyone a joint owner, it's worth discussing the decision with your bank or an estate planning attorney, so you fully understand the legal and financial consequences in your state. For many families, naming a beneficiary instead of changing ownership may accomplish the same goal while avoiding unnecessary complications. Again, every situation is different. The important thing is making an informed decision instead of relying on assumptions. Now let's talk about retirement accounts. Many people opened an IRA or employer retirement plan years ago. At the time, they filled out a beneficiary form and never looked at it again. Life changes, people remarry, families grow, relationships change, but the paperwork often stays exactly the same. Financial advisors regularly encourage clients to review retirement account beneficiaries because those designations can play a significant role in how assets are distributed after death. The same idea applies to brokerage accounts. Many investment accounts allow owners to name transfer-on-death beneficiaries. If you aren't sure whether yours does, call your brokerage firm and ask. A 5-minute phone call today could prevent months of confusion for your family later. Another point that's often overlooked is organization. Imagine your family trying to settle your affairs without knowing where anything is. They don't know which bank you use. They aren't sure whether you have a brokerage account. They can't find your insurance paperwork. They don't know where your retirement accounts are held. That creates unnecessary stress during an already difficult time. Instead, consider creating a simple document listing your financial institutions, important contacts, and where your estate planning documents are stored. Keep it somewhere secure and let a trusted family member know how to access it if needed. Notice I didn't say give them passwords. Just make sure they know where to find the information they'll need. Good organization is one of the most valuable gifts you can leave your family. Another helpful habit is reviewing your accounts every few years. Banks merge. Financial institutions update their systems. You move. Addresses change. Phone numbers change. Beneficiaries may pass away before you do. Periodic reviews help ensure your records remain accurate. If you're wondering how often you should check, many estate planning professionals suggest reviewing your beneficiary designations every 3 to 5 years, or whenever a major life event occurs. That doesn't necessarily mean you'll need to make changes. It simply gives you an opportunity to confirm everything is still correct. One important point I'd like to make is this. This video isn't about avoiding attorneys. It's not about avoiding estate planning. In fact, a properly prepared estate plan remains one of the most important investments you can make. A will serves a purpose. A trust serves a purpose. Powers of attorney serve a purpose. Healthcare directives serve a purpose. Beneficiary designations serve a purpose. They're designed to work together, not replace one another. Think of your estate plan like a puzzle. Every document is one piece. If even one piece is missing, the picture may not come together the way you intended. That's why reviewing your financial accounts is just as important as reviewing your will. Neither should be ignored. So here's a simple checklist you can complete this week. Log into your online banking, review each checking and savings account, ask whether a beneficiary is on file, verify that the information is current, review your retirement accounts, review your brokerage accounts, confirm your contact information is accurate. Store your estate planning documents somewhere your family can locate them. If you're unsure about any part of the process, schedule a meeting with your bank or a qualified estate planning professional. A short conversation today could prevent confusion years from now. None of us knows what tomorrow will bring, but we can make tomorrow easier for the people we love. Estate planning isn't really about money. It's about reducing stress. It's about making difficult moments just a little easier for the people left behind. The goal isn't simply passing along your assets. The goal is passing along clarity, because when everything is organized, updated, and properly documented, your family can spend less time dealing with paperwork and more time focusing on what truly matters, remembering the person they loved. If you found this information valuable, consider subscribing for more practical financial and estate planning insights. And as always, before making any legal or financial decisions, consult a qualified professional who can provide advice based on your specific situation and the laws in your state.